Article 9 of the Uniform Commercial Code, or UCC, governs secured transactions. In National Bank of Alaska v. Erickson, we explore whether Article 9 applies to real property. The National Bank of Alaska loaned Seaway Express over $9 million. In exchange, Seaway executed a credit agreement granting the bank a security interest in all of Seaway's accounts receivable, including proceeds from any unauthorized sale of such an account. Anchorage Fairbanks Freight Service, or AFFS, owed Seaway over $1 million. When AFFS failed to pay on time, Seaway took legal action to collect the account receivable. Ultimately, the parties settled. Seaway agreed to sell the account receivable back to AFFS, and in exchange, AFFS agreed to give Seaway a piece of land in Auburn, Washington. The bank, which knew about the proposed settlement, neither consented nor objected. After AFFS transferred the land to Seaway, the bank asked Seaway to record a deed of trust on the Auburn property in the bank's favor. Seaway refused. Seaway filed for Chapter 11 bankruptcy before it had fully repaid the bank's loan. Seaway sold the Auburn property and placed the sales proceeds into a segregated account. The bankruptcy was later converted to Chapter 7, and Warren Erickson was appointed bankruptcy trustee. In the bankruptcy proceeding, the bank asserted that it had a perfected security interest in the Auburn property because it was a proceed from the allegedly unauthorized sale of the AFFS account. In turn, the bank reasoned that it had a priority interest in the proceeds from the sale of the Auburn property. The bankruptcy court disagreed and granted summary judgment in Erickson's favor. The bankruptcy appellate panel for the Ninth Circuit affirmed. The bank appealed to the U.S. Court of Appeals for the Ninth Circuit.